afternoon, everyone, and welcome to this webinar on unlocking lockdown for vulnerable workers. My name is Helen Hogben, and I'm joined by my colleague, James McHugh. Say hi, James.
Hello.
And we're both barristers, employment law barristers at Trinity Chambers. Now, the objective of this webinar is to explore some of the practical issues for individuals who are currently shielding in line with public health guidance, and those individuals who live in a household with someone who's shielding. And hopefully we'll be able to offer you some tips on how to fairly manage those workers as businesses began to reopen across the course of this month. Now, you'll all be aware that this week the government outlined a further easing of those unprecedented lockdown measures which first came into force at the end of March, those measures that made it a criminal offence to leave our homes unless for one of a number of specified reasons. So of course from next Monday we'll be able to meet in outdoor spaces in a group of up to 6 people. And more importantly, from the 15th of June, we will potentially see a huge number of employees being asked to return to work in non-essential retail roles. So clothes shops, toy shops, bookshops and the like. That is of course provided that the government's 5 tests are met and that those businesses follow COVID-19 secure guidance. Now, the Chief Scientific Advisor conceded in yesterday's press briefing that sadly one of the consequences of easing lockdown may well be that there are localised outbreaks of COVID-19. And obviously that is a concern for all of us, but is a particular concern to those people at greater risk from COVID-19 and those people who are currently shielded. So it's going to be a really difficult path for businesses to navigate as they ask their employees to return to work. On the one hand, of course, they want to get their business back up and trading again, but they must not forget that the legal obligations in respect of health and safety, both of their workforce and of their customers. And it's worth reminding ourselves amidst all of the noise around businesses reopening, possibly from the 15th of June, that the default position remains that everyone should work from home unless they cannot work from home. Anyone also who is clinically extremely vulnerable, so for example, those who are undergoing chemotherapy, is strongly advised not to work outside the home and to avoid face-to-face contact. Arguably though, from an employment law perspective, the greatest impact of these changes that are likely to take place on the 15th of June are going to be felt by 2 specific groups of individuals. Firstly, those within the clinically vulnerable category, so not the high risk, but those at moderate risk from COVID-19. And those people who live in a household with someone who is clinically extremely vulnerable. Now, at the moment, as things stand, these people are not currently advised to shield, but they are advised to take measures within the home to minimise the risk. So keeping 2 metres away from people they're living with, sleeping in different bedrooms if they can, using separate bathrooms if at all possible, and so on. Now, both of these groups may well be asked to go back to work from the 15th of June, and unfurloughing them could present really practical difficulties for employers. So perhaps as a start point, employers need to look at the non-statutory guidance, which was updated on Monday. And I know, James, this is something that you wanted to discuss in more detail, isn't it?
Yeah, that's right. Thanks, Helen. There are 2 things that are important to note as a starting point in relation to this guidance. Firstly, that it is non-statutory guidance. And so although it's not going to be binding on employers, it's likely to be a fairly useful indicator of 1, what employers are expected to do, and 2, the view that an employment tribunal would take if there were complaints relating to these matters. The second important thing to bear in mind in relation to the guidance is that it won't only need to be taken into account in relation to the employees of a business, it will also need to be taken into account in relation to any agency workers contractors or other workers who work in the business. Running through the guidance, there are probably the following key points. Firstly, that employers will need to have particular regard, and that's the exact quote from the guidance, particular regard is the wording used, to individuals who are especially vulnerable to COVID-19. Those who are clinically extremely vulnerable are strongly advised not to work outside the home. Those who are clinically vulnerable, so in the slightly lower category than those who would perhaps be shielding, should be helped to work from home either in their current role or in a different role as an alternative to the one they currently fill. If clinically vulnerable individuals cannot work from home, they should be offered the safest available on-site roles, enabling them to stay outside of the current social distancing guidelines of 2 meters. If they do have to spend time within 2 meters of other people, then an employer will need to carefully assess whether this is an acceptable level of risk for them carrying out their role. Of course, employers will have to take into account, on top of this guidance, the specific duties that they have to those employees who have protected characteristics under the Equality Act. Particular attention should be paid to people who live with clinically extremely vulnerable individuals. Lastly, the guidance reminds employers, as if they needed reminding, that it is breaking the law to discriminate either directly or indirectly against anybody because of a protected characteristic like age, sex, or disability. And it also reminds them that they have particular responsibilities towards disabled workers and those who are new or expectant mothers. Obviously, there is a risk, therefore, to employers if they get it wrong. Helen, what are those risks?
Yeah, I mean, you've alluded to those a moment ago, James, because clearly what the guidance has done is it's placed Equality Act considerations fairly and squarely within one of those factors that employers have got to take into account when conducting risk assessments and managing employees back to work. So if we look first of all at that first category that I mentioned, those clinically vulnerable individuals, those at moderate risk from COVID-19. Now, those individuals are either people who are age 70 or over, or people under 70 with underlying health conditions. A complete list of those health conditions is on the government website, but many of you will be aware it includes people with chronic mild to moderate respiratory diseases, neurological conditions like MS, diabetes. It also includes pregnant women. And of course, employers may have within their workforce individuals who are pregnant, aged over 70, or who have one of those particular underlying health conditions. And of course, what we mustn't forget is that particularly conditions such as multiple sclerosis are already deemed to be a disability under the Equality Act. But many of the other underlying health conditions may also amount to a disability if an individual has an impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So employers really need to be alive to the risk of a range of potential claims under the Equality Act. So in a scenario where a clinically vulnerable worker indicates an unwillingness to return to work because of his underlying health condition, that could lead, for example, to potential claims of indirect discrimination or discrimination arising from disability.
Yeah, and I would also add to that, there is obvious potential for a duty to arise to make adjustments, and therefore a claim for failing to make reasonable adjustments. The most obvious example I can think of in relation to this would be if a physical feature of somebody's workplace meant that 2 meter social distancing couldn't be maintained, then an employer would need to think very carefully about what adjustments they could make either to the physical workplace or the job role to mitigate that risk where it wasn't possible.
Yeah. And of course, the second issue and the second group of people is those workers who are neither clinically vulnerable or clinically extremely vulnerable, but live in households with people who are. And again, it may well be something that many employers are unaware of, but they have protection potentially under the Equality Act also. And if they are subject, for example, to less favourable treatment because of their association with somebody who has a disability, then that could lead to a claim of direct discrimination potentially or harassment. So it's a big challenge for employers. I know, James, you're going to talk through some of the ways in which good employers will aim to deal with those challenges.
Yeah, thanks. The first and probably most important thing that they can do is to carry out an updated risk assessment in the workplace, taking into account the particular risks that are caused by the current COVID-19 outbreak. These are often viewed by employers as just a box ticking exercise. In this case, they're absolutely not. And you will find as employers that they are crucial to both protecting your staff and your business. Couple of things to note in relation to risk assessments. Firstly, if you've got fewer than 5 employees, your risk assessment doesn't need to be in writing, but we would say it's best practice for you to create that paper trail and put it in writing anyway. Secondly, what you need to be doing is thinking about the specific risks that are created by your workplace and your business, and looking at what steps you need to do to reduce that risk to the lowest level that is reasonably practicable. A lot of us are now already familiar with some of the measures that we're seeing in, for example, supermarkets. So one-way systems, plenty of hand sanitizer bottles around, limiting the number of people in a shop at any one time, protective screens for checkout employees, things like that. But again, on top of those measures that I think at least some of which could be applied to every business, it's important to think about what the particular nature of your business is. Some of the challenges that might come up are, if, for example, you've got a small high street shop with businesses on either side, how are you, and more importantly, how are you going to get your staff to manage outdoor queues without putting them at risk? What cleaning procedures and regimens are you going to have to put in place? Because, of course, the guidance will talk about, when making your place of work COVID secure, as the phrase the government likes to use, you're going to have a regular cleaning regimen, and you need to think about what that's going to be. Another potential challenge is if you've got, for example, a clothing shop, are you going to close your fitting rooms, and how are you going to manage returns of products?
Yeah, and I suppose that feeds into as well the concern about repeated customer handling of products as businesses reopen. And one of the areas of the government guidance and tips, I suppose, for employers is that businesses should, particularly, for example, furniture shops, should consider placing protective coverings on larger items that may require customer testing or use, and clean those protective coverings regularly. Well, that's easier to achieve if you've got a business like a furniture retailer. But what if you're an independent bookshop where customers frequently come in and browse the shelves and leaf through books and so on? It's going to be a real challenge for employers to think creatively about how they limit customer handling of products and what steps they put in place.
Yes, and I think just on a general point in relation to that, what we would say is 2 things. Firstly, it is an unprecedented situation, and I think employment tribunals generally are going to be cognizant of the fact that these are challenges that a lot of employers are going to have to face for the first time, and they're, I suspect, going to be sympathetic to employers who have tried to do something rather than doing nothing. And the second point would be that perhaps the most important point is that you have to pay particular attention to those workers who are vulnerable for the reasons that we've set out before.
Yeah. And once you've done your COVID-19 risk assessment following the guidance, and if there are any concerns about how to carry out that risk assessment, there are useful tools on the Health and Safety Executive's website, so it's definitely worth employers checking those out. But once you've carried out your COVID-19 risk assessment, the next thing to do is share that risk assessment with your workforce. If you're a larger employer and you employ 50 people or more, then the government expects you to be able to publish that risk assessment on your website. So there's transparency for both workforce and customers. If you're a smaller employer, or for any employer, but particularly smaller employers of under 50 employees, then within the guidance, there is a government notice that you can complete, that you can display on your premises to show your workforce and your customers that you have been responsible and you followed the guidance in reopening.
Just lastly, on that point, I think it's important to remember that the default position is that everybody should still be working from home if they're able to do so. There was a well-publicised case this week of Dyson getting into trouble because they'd attempted to bring their employees back into the workforce when in fact the guidance was that they didn't have to be there, and they had to make a fairly public and embarrassing climb down in relation to that. So it's important to remember the default position is still everybody should be working from home if they can. But of those people who are working from home, it's important that employers are monitoring their well-being and not feeling like they are cut off or at some sort of a detriment because of the fact that they are working from home. What that leads into, and I think that probably the next important thing after risk assessments, is your ongoing communication and engagement with your employees. There are several things that employers can be doing in relation to that. The first thing is, where possible, make sure that you are training your employees to ensure that everybody understands and is familiar with the new ways of working. The second thing that employers can be doing is communicating effectively with their workforce so that everybody understands what the new measures are, and the employer is aware if there are any disagreements with that new way of working. Ongoing engagement with your workforce is crucial so that if problems arise as a result of the new ways of working, they can be dealt with very quickly. Lastly, in relation to communication, it's important that employers think about how you are going to let your suppliers and customers know that you are operating under a new procedure. That's going to make your employees' life much easier on the ground if you're not having to field questions from either suppliers or customers about why things are being done differently.
Yeah, absolutely. And I suppose as we enter this really uncharted territory going forward, potentially from the 15th of June, now is the time, if you haven't done so already, to really have a look at updating your internal policies and procedures to put you in the best shape to be able to manage your business going forward. So your grievance and disciplinary procedures, for example, capability and sickness absence management. We know that the COVID-19 guidance, the updated guidance from the 25th of May, puts Equality Act considerations fairly and squarely for the employer's consideration in conducting risk assessments. So make sure that you have a robust equal opportunities policy. And also, one thing not to forget is that there will be bumps along the road as you reopen, inevitably, and in some circumstances, it may well be that employees are concerned that managers or other fellow employees are not following the measures that should be in place in line with your risk assessment, and that may well endanger their health and safety or the health and safety of others. So therefore, you may want to think about, and it may well be helpful for you to think about updating your whistleblowing procedures to make sure that if employees do wish to raise a complaint, they know how to do it. The reality is that employers may well have to deal with a range of complaints in the months to come, as everyone gets used to the new ways of working. And so having a suite of transparent policies will certainly help employers to deal with those complaints fairly and reasonably.
Yeah, and I think probably the last thing to say before we finish off is that if any employers are in doubt about what to do, the best course of action is to seek advice. You're not going to be the only ones who are in a difficult position here facing things for the first time. And there are people out there, us included, who are in a position to offer advice and guidance on the best way to implement these new procedures and policies. That wraps this session up. We'd like to thank you very much for watching. If there are any queries arising out of today's topic, any of the other webinars that you might have seen, or if you've got any suggestions for future webinars, there'll be contact details at the end of this video. But in the meantime, I hope everybody stays safe. Thank you very much for watching. Goodbye from me.
And it's goodbye from him. Thank you.
Thanks.